Okay, well, good morning, everyone. My name is Professor Dwight Newman. I'm a professor here at the College of Law and chair of the Guest Speakers Committee for this academic year. And I'd like to extend a warm welcome to everyone who's joined us for today's lecture, whether here in the room or I know there are also many watching on the live stream. And we're glad that you took time out of your day to join us for this event. As we begin today's event, the University of Saskatchewan acknowledges that it's located on Treaty 6 territory and the ancestral homeland of the Métis people. In honoring this land's rich history, the university pays its utmost respect to the First Nations and Métis ancestors who've shaped this place, and in doing so, seeks to reaffirm its relationships with them. Today, we have the pleasure of welcoming the 2026 Silas E. Halyk, KC, Visiting Scholar in Advocacy, Daniel Shapiro, KC, C.Arb, to deliver today's lecture. The Visiting Scholar position, also known as the Halyk Chair, was created in the fall of 2009 thanks to a generous gift from Silas Halyk, along with additional gifts from Si's friends and supporters. These gifts support an annual visit from a distinguished legal advocate who delivers this lecture and spends time with our students who are involved in various advocacy programs and courses. And we're working him hard this week. He has a lot of different classes to work with. Over the years, gathering for this lecture provided us with the opportunity to note and honor Si Halyk's exceptional legal career. Si was born and raised in Saskatchewan and earned his LLB from this college in 1961. He was a leading lecturer in the Federation of Law Society's criminal law conferences in the 1980s and 1990s, represented many prominent clients, and served as counsel in several public inquiries throughout the country. He was especially honored to be chosen by what was then the Federation of Saskatchewan Indian Nations, FSIN, with a new name now, as their counsel on several occasions, including representing them at the Neil Stonechild inquiry in 2003. The Silas E. Halyk KC Visiting Scholar in Advocacy was created because Si had a desire to help USask law students learn how to become good courtroom advocates. As such, the position is bestowed upon a prominent legal advocate. And I have the honor of presenting today's speaker who fits ably that category. For almost 3 decades, Mr. Shapiro handled numerous civil, medical negligence, injury, wrongful dismissal, insurance, labor relations, and human rights cases. He appeared as counsel in all levels of court throughout Saskatchewan and Alberta, as well as the British Columbia Supreme Court, the Tax Court of Canada, and the Supreme Court of Canada. He served as counsel in many precedent-setting court decisions across various areas of law. And then, since 1994, after completing formal mediation training, the focus of Mr. Shapiro's practice shifted from the role of advocate to that of a neutral, which has been exclusively the case since 2000. Mr. Shapiro taught trial advocacy at the College of Law, University of Saskatchewan, as well as in many continuing legal education programs. He's also been a frequent guest lecturer in the fields of ADR, medical negligence, Aboriginal justice and policy, and labor arbitration. He served as the president of the Saskatchewan Trial Lawyers Association, member of the CBA National Health Law Section, and inaugural chair of the CBA Saskatchewan Branch Health Law Section, amongst many other roles within the legal profession, including as district governor for Saskatchewan and Manitoba of the American Trial Lawyers Association. From 2020 to 2025, Mr. Shapiro served as court-appointed consultant to the mediator, retired Chief Justice Winkler, regarding the development of the Pan-Canadian Compensation Plan and Quebec Administration Plan established for the benefit of victims of tobacco-related diseases, and was involved in those proceedings throughout that period. Upon the ultimate approval of the settlements in 2025, Mr. Shapiro was appointed by Ontario Chief Justice Morowitz as administrative coordinator concerning the administration of these plans. This work builds upon Mr. Shapiro concluding in 2021 a multi-year project adjudicating and ultimately leading the Independent Assessment Process, IAP, and Indian Residential Schools Adjudication Secretariat, created by what was then the largest class action settlement in Canadian history. I could go on with more things. He's done an enormous set of things within the legal profession, but you'd rather hear from him than from me. So please join me in welcoming Daniel Shapiro.
Thank you very much, Dwight, for those kind words. And welcome, everyone. Dean Phillipson, faculty, staff, students, and Marie. Did I leave anyone out? I hope I've got everyone covered. I'm honored to be here as the 2025-26 Halyk Chair in Advocacy. Cy was a giant in our legal community, and his passing just over a year ago remains a huge loss. He was a mentor to many, and by dumb luck of being located in the same office building that Cy was in, I ended up having the privilege of being invited to co-counsel with him in civil trials that were well beyond my depth as a junior lawyer. And he became a wonderful lifelong friend. And at full circle, we ended up working together later in our careers in the independent assessment process. More about that later. But his visiting scholar program, and Professor Newman shared some of that, it's been very enthusiastically supported by the college community, as is shown today by the number of people that are here. So it's wonderful that tradition that Cy started is being carried on by Catherine Knox, his partner. I also had the privilege of working closely with Catherine when she was a deputy chief adjudicator in the IAP. So these are just a few of the many reasons why this chair is especially important to me. Big shout out to the Dean Phillipson, to Dwight Newman, and to the remarkable college staff, Katie Richard and Stacy Shawega, for the amount of work that went into making this week's events possible. 50 years ago last September, I entered the college. A long-haired 19-year-old. I know it may be hard to believe looking at this now. If I would have stayed in law school any longer, I'd be right down to the concrete. But I came out here in 1975 with my then girlfriend, Marie Lanoux, now my wife, little imagining that we would end up making Saskatoon our home for at least the next 5 decades. Raising our 2 boys, and we would study, work, and live here, and we're still happily here. I'm going to try to paint a little picture of what things were like in 1975 here at the college. Law school tuition was $600 a year, and we paid rent of $85 a month for a beautiful downtown apartment. I'd like to talk a bit about my classmates and students. The secret to whatever sparse academic success I enjoyed in law school was surrounding myself with brilliant people. I was in a study group with 3 women, and I have reported frequently that 3 of the 4 of us finished in the top 10. The fact that I wasn't one of them doesn't diminish from the overall accomplishment of the group. I like to think that my Tort study notes propelled them into the winner's circle. Wanda Wiegers, now Professor Wiegers, was in my study group and has a very well-established, respected career as a law prof. Another classmate, Don Morgan, went on to become Saskatchewan's Justice Minister and Labor Minister. Clem Chartier would become a longtime president of the Métis National Council and also the World Council of Indigenous People. And Beth Bilson, who was bound for stardom as an administrative law guru, she was a year ahead of me, and it's been said that the college has only had 3 female deans, and Beth was all 3 of them. She too was a much-loved friend of the Saskatchewan legal community, and was especially admired for her mentoring of women lawyers. Her recent loss has been deeply felt by the college. As to faculty, Dan Ish was a first-year teacher at the college in tax and torts, and he would go on to become a 3-time dean. Peter McKinnon, my criminal law prof, in first year went on to become a dean and a long-serving president of the university. And in 1975, Roger Carter launched the Native Law Center. And that continues to prepare and inspire Indigenous students from across the country towards legal education. So in short, it was really an exciting and stimulating time. And I'm sure those phenomena are present today for the students and faculty of 2026. So I started down the path of criminal law at the Saskatoon Legal Aid Clinic, but a labor disruption there ended my articles, and I was fortunate to be taken on by my contracts and real estate prof, Garth Sandstrom. As it could not be said that I excelled in either subject in law school, I couldn't have imagined that within a week of being called to the bar, I would be an active co-counsel in a lengthy Queen's Bench trial of a commercial real estate dispute. To my surprise, I enjoyed commercial and later personal injury and tort litigation. And ultimately, I ended up specializing in high-risk medical malpractice cases on behalf of the catastrophically injured before, as Professor Newman talked about, shifting my practice to mediation and arbitration. But the litigation practice did lead to a number of the areas that followed it. In 2001, I was appointed by the Superior Court of Ontario as an arbitrator under the Hepatitis C class action settlement, which is continuing to date. And starting in 2003, adjudicating Indian residential school abuse claims. In 2007, I was appointed as a deputy chief adjudicator for the residential school secretariat. And in 2013, I became the third chief adjudicator of the secretariat. I succeeded two chiefs who had very strong connections with the college, both of whom were inspiring leaders and mentors and became lifelong friends. Ted Hughes was a U of S law grad, former Saskatchewan Court of Queen's Bench judge and Deputy Attorney General of BC, and Dan Ish, who we heard about earlier. And interestingly, the college produced many of our IAP adjudicators. Our head office was in Regina, and it made sense that Saskatchewan would play such a central role in the resolution of those issues, since we were right at the epicenter of the failed Indian residential school experiments. The Native law in the college helped to equip Saskatchewan adjudicators and also Saskatchewan lawyers to address one of the darkest chapters in our shared legal history. So again, I didn't imagine my litigation path would lead me to that, to become immersed in this project of a historic magnitude, but it really was one that I hoped would make a real difference in people's lives. And this led me to respond to a Globe and Mail ad, and ultimately to a once-in-a-lifetime opportunity. So briefly, the resident, and Professor Newman mentioned that the residential school settlement agreement was then the largest class action settlement in Canadian history. It was also brokered by retired Supreme Court of Canada Justice Frank Iacobucci. And the agreement was unique in the world in trying to comprehensively redress historic wrongs perpetrated by the state and churches against Indigenous children. And the independent assessment process was one of 5 elements of this settlement agreement we just discussed. And it is the focus of today's presentation, Advocacy for a Process. And I fully appreciate and respect that there are many perspectives on the history of the process I am discussing here. And so I'm simply offering these views as my own. For me as a non-Indigenous Canadian, it was a profound and life-changing honor to meet and learn from so many of the extraordinary and inspirational residential school survivors from all over the country. It is for history, the parties to the agreement, and first and foremost, those survivors to say whether the IAP met their hopes and expectations. Before getting into those, I would like to just do a very high-level view of the historical context that gave rise to the settlement agreement. And I would argue that without any one of these steps, there wouldn't have been a settlement agreement. But briefly, there had been earlier efforts to establish residential schools, even as early as the 1600s in New France. But by 1883, the government had formalized a policy with the of residential schools for Indigenous children. They established 3 residential schools in Alberta and Saskatchewan. The schools were funded by the government and administered by the Christian churches. And they were unapologetically designed to separate children from their families, to civilize them, and to get rid of the Indian problem. Unfortunately, ultimately, more than 100 residential schools operated in every province and territory except PEI in New Brunswick. And by the time the final school closed in 1997, more than 150,000 souls, First Nations, Inuit, and Métis had attended residential schools. While the experience was not the same for everyone, for most, the experience was profoundly negative and had lasting negative impacts not only on the children who attended, but on their families, their communities, and their cultures. Some children, even as young as 3, were forcibly removed from their families. And while some attended schools on their reserve, many were taken to distant communities. Practices varied over time and from one school to another, but we heard of school staff discarding the clothing the children arrived in, assigning them English or French names or even numbers, which they were often referred to by throughout their school years. It was forbidden typically to use their language, follow their spiritual beliefs, or practice their cultures. I can recall more than one survivor talking about having their, he was a young male at the time, having his braids shorn when he got to the school. And he said for him and his community, having your hair shorn was a sign that there'd been a death in the family. So he said that, people in his community for going to that school were convinced that there'd been a large number of deaths in their home community. That's just one of many, many examples. Well, the students could face extreme discipline, forced labor, physical, sexual, and psychological abuse. So today I hope to stimulate dialogue about the choices that were made to address these wrongs, and also to discuss possible future directions. There was a lengthy dialogue leading to the settlement, and I'll condense it, but in 1991, Phil Fontaine, who was then the head of the Assembly of Manitoba Chiefs, stunned the nation by testimony of being physically and sexually abused at a residential school. He told the CBC's Barbara Frum, in my grade 3 class, if there were 20 boys, every single one of them would have experienced what I experienced. They would have experienced some aspect of sexual abuse. So his courageous act really was pivotal in bringing residential schools abuse into the public consciousness in Canada. There was a 1996 Royal Commission on Aboriginal Peoples that recognized the need to completely restructure the relationship between Aboriginal and non-Aboriginal Canadians. An entire chapter was devoted to residential schools. By 2020, there had been a series of exploratory dialogues involving survivors, Canada, and churches, which recommended development of a number of models for resolving disputes arising from residential school abuse. Between 2000 and 2003, there were pilot projects which used independent contractors who helped the parties negotiate the settlement of claims, but lacked the authority to award compensation. In 2002, the Kaufman Inquiry examined the process used in Nova Scotia to compensate victims of abuse at a school for girls. Kaufman found that process so seriously flawed that, and I'm quoting, it left in its wake true victims of abuse who are now assumed by many to have defrauded the government, innocent employees who are branded as abusers, and a public confused and unenlightened about the extent to which young people were or were not abused while in the care of the province of Nova Scotia. And this is important because the Kaufman report was released just before the residential school settlement agreement and articulated the need for a credible process, which I think it's obvious that it influenced the parties who agreed that in the IAP, abuse findings would require proof on a balance of probability. So from 2003 to 2008, the process that I was also involved in, Dan Ish and others were as well, the alternative dispute resolution process was a significant step forward. Despite its shortcomings, for the first time, adjudicators could issue awards. And in that case, they were binding on Canada, but the survivors were free to accept or reject them. And approximately 5,000 ADR claims were concluded. By this time, it had become obvious that litigation alone could not resolve these disputes for sheer numbers, if for no other reason. By the settlement agreement, out of close to 20,000 claims, only 2,200 had been settled, and only 36 trials had taken place. One trial alone rising out of the Alberni Indian Residential School, Blackwater and Plint, included a 115-day trial spread over 3 years and almost a decade to conclude, ending up at the Supreme Court of Canada. Canada estimated it would take 53 years to resolve the outstanding claims in court. Survivors, Indigenous organizations, and some church entities were pressing for other avenues for redress. A pan-Canadian settlement of the many class actions underway was the only viable option. So we're getting close to the settlement agreement. In 2005, an agreement in principle was concluded with over 80 signatories, including by then AFN National Chief Phil Fontaine, representatives of the Inuit, and many lawyers representing survivors. Designed to be holistic and comprehensive, it ultimately led to this largest class action settlement in Canadian history. In 2006, the residential school settlement agreement consolidated thousands of individual lawsuits into a single class action settlement approved by courts in 9 provincial and territorial jurisdictions. The settlement agreement, I will argue, was a significant step on a difficult path towards recognizing and healing the past. The settlement agreement included 5 elements: a 5-year, $125 million endowment for an Aboriginal Healing Foundation, $20 million for commemoration initiatives, a common experience payment designating close to $2 billion to compensate all surviving former residents of residential schools based only on how many years they attended. So it was a no-fault payment, no proof required other than proof of attendance. The Truth and Reconciliation Commission, or TRC, was the public education side of the settlement agreement. It had $72 million in initial funding, while it was mandated to compile a historical record, create public awareness, and pave the way to reconciliation. And finally, the independent assessment process to address individual abuse claims. The process addressed shortcomings in the ADR process that preceded it, provided for confidential in-person hearings administered by an adjudication secretariat. So you look at these 5 elements of the secretariat of the settlement agreement, and you'll say, there's never been anything like this beforehand, and there certainly hasn't been anything like it afterwards. So that's why I think this discussion is so important in terms of the choices and choices that were made at the time and also in other settlements that followed. But I will say that the opportunity for survivors to share their experiences was in a private, unsupported setting. That was a core principle. People were given 5 years notice and ongoing notice that they had 5 years to apply. So at the outset, 12,500 claims were anticipated. There's no living person that will claim responsibility for that number, so we just don't know where it came from. But that was the number that we were set up as a Secretariat of Claims to resolve. If the parties had understood the volume of claims that would emerge, would they have chosen a different compensation process? In the end, we had over 38,000, almost 38,300 claims. So this is a valid question. Still, the one thing we can say is that if the agreement in principle had failed to survive the change in government in November 25, it could have been many years before any other plan would have taken shape. And you'll recall that the Kelowna Accord fell with the change in government. The only part of the Kelowna Accord to survive was the settlement agreement. So you could tell that given the urgency of the problem, the aging survivor population, leaving this for another day was simply not an option. Okay, how did the IAP hearing process differ from a court hearing? Well, like the court system, the IAP was designed to be fair and impartial, but there were significant differences. The IAP was claimant-centred, with healing and reconciliation as its core objectives. Now, this did not mean that every survivor was compensated, although in the end about 90% were. Rather, it meant that survivors were to be respected and to feel heard regardless of the outcome. Hearings could include and did include traditional ceremonies such as smudges, songs, and prayers, and survivors could be supported at hearings by elders and Indigenous health support workers. The IAP was to be non-adversarial. Government was always represented at the hearings, and churches sometimes were, but only the adjudicator questioned the claimant. So this is a big difference than in the courtroom, where you could expect to be led through your testimony by your own lawyer and then be cross-examined by a government lawyer, a church lawyer, an alleged perpetrator lawyer, and maybe the judge. Not exactly welcoming to people that were going to be dealing with such detailed and intimate experiences. A big factor, hearings were held in private with confidentiality agreements signed by all. Claimants could choose the gender of their adjudicator and the location of their hearing. We held many hearings in homes, on reserves, hospital rooms, lawyers' offices, even correctional facilities. The adjudicators were selected by the stakeholders and required the unanimous approval of the AFN, Inuit, claimant lawyers, churches, and government. Through cultural competency training, we were encouraged to create opportunities for healing and reconciliation. This was not always achieved, as some adjudicators were more effective than others, but the objective remained constant. The IEP gave the government and churches the opportunity to formally apologize to survivors. When requested, the Protestant churches sent representatives not to defend claims, although they were entitled to do that, but to support and apologize to survivors. Written apologies were offered to those who wanted them. Still, I don't want to sugarcoat this. These were stressful and challenging days for survivors, and not all claimants had positive experiences. The process could reopen wounds for those who felt unprepared or unsupported. Still, many former, if not most former students told us they felt lighter after their hearings and initiated hugs with their adjudicator. So that's a bit about the process. What compensation was awarded. There were, the average compensation award was $91,500. Compensation was available up to $275,000, depending on the nature and severity of abuse and the harm suffered. Adjudicators could also award another $250,000 for actual income loss, though those claims were few. And for income loss claims above that, people had the option of going to litigation. Overall, more than $3.2 billion was paid to about 28,000 survivors, and that included compensation, legal fees, and disbursements. The secretariat that I worked with had about 275 people working in offices in Gatineau, Winnipeg, Vancouver, and Regina. The 100 adjudicators, 8 deputy chief adjudicators, and chief adjudicator managed up to 4,500 in-person hearings annually. Our staff were running what was clearly the biggest travel agency in the country, as they were arranging for survivors, their supporters, translators, adjudicators, and others to go to all corners of the country. It was challenging to ramp up efficiently when nobody knew how many claims would be filed. And in fact, about 8,000 or 9,000 claims were filed in the last 30 days of the IAP. And there are stories of this giant fax machine in the hands of the administrator that started on fire due to the sheer volume of claims that were coming in. That's difficult to plan for, but it's understandable that people wanted to get their claims in before the process came to an end. And then closing the process at the end with a hard stop was challenging because many staff had already switched to remote work by that time due to the pandemic. So our priority was to strive to ensure a safe, respectful setting in which survivors could share their experiences. The process held powerful potential for transformative change. Individuals had their experiences acknowledged and validated, and in many cases heard heartfelt words of apology from government and church reps they thought they would never hear. So creating these experiences in a safe environment for survivors was our top priority. Now, when I stepped into the chief adjudicator's role, and Danish warned me of this, I had no expectation of being universally loved. Even so, we faced an astonishing number of unexpected challenges, most related to the sheer volume of claims. Others, however, arose from the misconduct of claimant lawyers and an influx of challenges to adjudicator decisions, and still others concerned the eventual disposition of claimant files. I'll discuss each of these in turn. As to the volume, if we had received the 12,500 claims that were anticipated at a rate of 25 hearings per year, we would have concluded all of those in 5 years. We had to change our procedures as a result of the volume, change our administrative structure to try to speed things up. It was difficult to retain and recruit adjudicators because government procurement processes, especially in an organization like ours with a limited lifespan, moved at glacial speed. And even when we were handling 4,500 cases a year, it took longer than expected to resolve claims. This meant that some claimants had a long wait for resolution, and sadly, some passed away before having a hearing. Exploitation of claimants by certain lawyers. One significant area of difficulty was the role played by lawyers and agents in recruiting claimants and the financial exploitation of clients by some lawyers. How did we respond to those challenges, you ask? Well, the settlement agreement stipulated that if a claimant was legally represented, the lawyer would be paid 15% by Canada, and the courts decided that lawyers would be able to claim another 15% of compensation if the adjudicator approved it. So the courts, not the parties, asked adjudicators to review legal fees in every case and to reduce the fees if we found them to be unfair or unreasonable. And I stress that most of the IEP counsel were excellent and highly ethical. I can think of one lawyer that I worked with a lot in northern communities, a fellow by the name of Len Marchand, who's now the Chief Justice of the BC Court of Appeal. So we had some of the best lawyers that you would ever find, but there were problems that came to our adjudicators' attention through the supervision of legal fees, and they presented serious challenges that couldn't be ignored. This put us into conflict with the claimant counsel who appeared before us. I'll mention just some of those who have been publicly identified, just to give you a flavor for the challenges that we were facing. David Blott was an Alberta lawyer who represented 4,700 survivors, and he earned millions while spending little time with these clients. He outsourced much of the work to a non-lawyer form filling group and often met his clients for the first time on the hearing day. This was something that fell well short of the expected standards. Eventually, however, with Canada's support, his practices led to his judicial removal from the IAP and ultimately to his disbarment. Howard Tenenhouse was a Winnipeg lawyer who failed to comply with our adjudicator's orders to return $1 million in legal fees to his clients. He left the country and was disbarred. Fortunately, those fees were ultimately returned to the clients through the work of the Law Society of Manitoba. Stephen Bronstein was a BC lawyer with 1,400 IAP claims, and he thought it'd be a good idea to hire a paroled convicted murderer as his form filler in a northern community in BC. There were allegations that this form filler improperly demanded payment from clients when they were about to receive their settlement proceeds, and sometimes accompanied them to their bank, accompanied with threats of violence. Now, this was shocking to learn about, and we just didn't want to believe that this was even possible. Clients were reported to have complained to their lawyer, left messages, but to no avail. So this is where things became very difficult. Mr. Blott had been removed for far less serious allegations, yet my request to have Mr. Bronstein removed from the IAP were not accepted by the courts. The BC judge found his conduct fell below the expected standard, but allowed him to continue under supervision. Ultimately, but after his lucrative IAP work was concluded, the BC Law Society's discipline panel upheld a plea agreement resulting in a 1-month suspension, a practice review, and a commitment not to act for 60 scoop survivors, paying $4,000 in costs. There was a strong dissent, and that was by bencher Karen Snowshoe, who was one of our former adjudicators, who found the penalty was grossly inadequate. And it doesn't stop there. Ron Cherkowich, a Saskatchewan lawyer, refused to show his client's fee agreement to an adjudicator as he was required by court order to do. At the hearing, he drafted one on toilet paper, and he threw it at the adjudicator, who was a young female Indigenous adjudicator. Manitoba form fillers, our adjudicators learned that some lawyers had affiliated themselves with non-lawyer form filling agencies that charge an extra 15% above their lawyers' fees. Now, this subverted our legal fee review process because the lawyers didn't produce the form fillers contracts, so adjudicators were missing the complete picture. It was also confusing for survivors. At the court's request, and through the remarkable efforts of Catherine Knox, who was a former Mount Cashel abuse prosecutor, we brought 2 pilot cases before the Manitoba supervising judge. In one case, rather than receiving her settlement check directly from her lawyer, a woman from northwestern Ontario who was undergoing cancer treatment was sent a bus ticket to travel for the long trip to Winnipeg to collect her check. There, she was marched from her lawyer's office to her bank by 2 workers from a form filling agency so they could collect their cut. The woman was not sure what was going on and was too afraid to complain or object, according to the judge. The court ruled that form filling agencies, which we had learned were large and well-financed, were not allowed to charge contingency fees, and such agreements were found to be unconscionable and void. Claimants were under no obligation to pay any fees in relation to their IAP claims other than legal fees approved by adjudicators. So somehow Catherine managed to find this person, get an affidavit from her, and even to have her appear on The Current with myself and Anna Maria Tremonti to share her experiences. I mean, it was really quite a remarkable turn of events. We'll never know how many hundreds or even thousands of claimants may have been disadvantaged if we weren't able to put a stop to this practice. The Merchant Law Group, the settlement agreement prohibited the assignment of settlement proceeds to ensure claimants received the entirety of their settlement. Merchant Law Group received settlement proceeds on behalf of an IAP client known as JS. They had earlier done other legal work for her and had represented her son on a criminal matter. Mr. Merchant wrote to her, acknowledging that although his firm had no legal right to enforce an assignment against her for these criminal matters on behalf of her son, and would not hold back funds unless she agreed, he wrote, we could sue you for the $21,300. My expectation is we would succeed and obtain a judgment against you. We could then seize your assets, your car, your bank account, or whatever. And so JS, after receiving this, signed a document allowing Merchant Law to deduct the $21,300 from the proceeds of her award. So the retired judge, who was designated as an independent special advisor, found that funds were improperly withheld, and Merchant Law Group did return the funds to JS, but challenged the decision in court after that. The BC Court of Appeal ultimately confirmed that the document signed by JS was an assignment of funds prohibited by the settlement agreement, and Mr. Merchant's application for leave to appeal to the Supreme Court of Canada was denied. The saga did not end there. Mr. Merchant was ultimately prosecuted for conduct unbecoming under the Saskatchewan Legal Profession Act arising out of these facts. The discipline panel was chaired by Beth Bilson, rejected Mr. Merchant's assertion of an honest but mistaken belief that what JS signed did not amount to an assignment. An 8-month suspension was imposed. Ultimately, however, the Saskatchewan Court of Appeal rejected the panel's findings, overturned the conviction. One small mercy is that that decision was handed down in 2022, about a year after the IAP had wound up. That's a small mercy. Otherwise, the net outcome for many survivors may have been dramatically different. Okay, the confidentiality of claimant files. So in addition to managing to get into legal conflict with certain claimant counsel and form filling agencies, I ended up in protracted litigation over control of IAP records, this time with others. The TRC initially began negotiating with the IAP Oversight Committee to develop a consent form the claimants could sign to allow for archiving their records. But then the TRC evidently realized that if claimants had the opportunity to say yes, they might also say no. And the TRC abruptly changed course, withdrew from these negotiations with our oversight committee, and after years of fighting things out with Canada in the courts, joined forces with Canada to seek compulsory transfer of every IAP file, even where claimants were opposed. While I continue to applaud the TRC for its magnificent work informing the public of the residential school legacy, this was a troubling turn of events. These files contained the most deeply sensitive personal information possible. Every hearing began with a confidentiality agreement signed by all participants: adjudicators, claimants, lawyers, and government reps. The promise of confidentiality contained in the IAP and reaffirmed at each hearing was the biggest single factor in allowing survivors to share their experiences without fear of their most personal information being disseminated throughout their families and communities. Yet Canada and the TRC, and after the TRC dissolved, its offspring, the National Centre for Truth and Reconciliation, after Canada had signed all these agreements in tens of thousands of cases, later argued in court that confidentiality meant confidentiality within the meaning of Canada's suite of privacy and access legislation, just what everyone would imagine if they were told about it. In other words, the claimant files would go to Library and Archives Canada. The legislation there protected personal information from disclosure for only 20 years after the death of the relevant individuals. Some disclosures were permitted even within that protection period, and alleged perpetrators of abuse were not prevented from seeking information about their accusers. Files transferred to Library and Archives Canada would be available to the public 100 years after the death of affected individuals. So that on that case, so that was the TRC on one hand saying, we want everything. And on the other side, we had a not all, but certainly a group of Catholic church entities that argued that no files could be archived without the consent of the church or the alleged perpetrator, even where the claimant believed or agreed to that. So as a head of the tribunal, I can tell you with some certainty that the very last thing I would have wanted was to get into litigation with Canada, the lead defendant, the TRC, which could do no wrong, and some church entities. But not just every one of our adjudicators, but I had, in every case that I had, made a solemn promise of confidentiality at the start of every hearing. And survivors sometimes went to extreme measures to preserve their privacy. Some requested a hearing far away from home. The prospect of personal histories being shared caused some to become physically ill. And I just couldn't imagine betraying these people. I felt it imperative to stand behind the promise we had made to them. As in the lyrics to Leonard Cohen's song, Heart with No Companion, which our then lead judge, Warren Winkler, recited every time he got a chance to speak about our process, though your promise counts for nothing, you must keep it nonetheless. And those were words that I and my team tried to live by. Both I and the TRC asked the supervising court for directions on what would happen with our records. My request that the records be destroyed unless survivors chose to archive them was highly controversial and attracted much media attention nationally, although we had retained a privacy expert who provided an opinion that destruction is part of the natural life cycle of such documents. I had one person who was relentlessly hectoring me every time an article came out in the media, and then once I got an email from them calling me a Nazi book-burning nut. And before I could resist the urge to just maybe think about it overnight, I hit the send saying, "This time you've gone too far by calling me a nut." But that was really part of the environment we were dealing with. I did have a dream team representing my case. We had last year's Halyk chair, Catherine Boyce Parker, Susan Ross, who is another deputy chief adjudicator and privacy expert. She's from Victoria, and Joe Arve, our brilliant lead counsel, who passed away in 2020. Joe took on the case with everything he had. He was in the very best tradition of our profession. He was a prolific charter advocate, appearing in over 75 cases at the Supreme Court of Canada and obtaining landmark decisions before he passed away in 2020. His victories earned him the nickname the Court Whisperer. And never have I been prouder to be part of our profession than when watching Joe argue the records case before the Supreme Court. And for those of you interested in advocacy, if you get a chance to listen to and watch Joe's argument before the Supreme Court, I will promise you that it is spellbinding, and the court was spellbound. Ultimately, with the support of the AFN and the Inuit, we prevailed in a unanimous decision. As we had proposed, claimants alone were given the choice to archive their materials, their application forms, hearing transcripts, audio recordings of hearings and decisions with the National Centre for Truth and Reconciliation in Winnipeg. These documents are stored with a records agent until September 2027, at which time they'll be destroyed. But the litigation was high stakes and hard fought, with the full weight and resources of the federal government brought to bear. The largest group of plaintiffs' counsel who signed the settlement agreement did not participate in the litigation. Only a small number of independent counsel signatories did. Unfortunately, this litigation took 5 years to resolve, and during that time, the anxiety that survivors experienced, knowing that the TRC in Canada were pursuing access to their confidential records, was in many cases severe. By the time we closed our doors, out of tens of thousands of claimants and after a multi-million-dollar court-approved national notice program, fewer than 30 people had chosen to archive their records. Now, this is strong evidence of the importance of confidentiality and the concept of agency to survivors. Judicial recourse, I'll just spend a minute talking about this, but this is important to how things turned out for us. Initially, the lead judge, who was Warren Winkler, wrote a decision, it was called the Schachter case, finding that lawyers who signed on to the settlement agreement gave up their rights to relitigate matters in court. There was a process for internal review by different adjudicators, but it ended there. There was no recourse to the courts. And although he was the Chief Justice of the Court of Appeal then, he was acting more or less as a trial judge because he actually took the residential schools file with them from Ontario Supreme Court to the Court of Appeal when he became Chief Justice of the Court of Appeal. So it was a complex litigation to figure out how the court without him was going to deal with this case. And really, it created the Ontario Court of Appeal opened the door to allow judicial recourse in what they called exceptional circumstances. The court may have believed it was just opening the door a crack, but it created a major litigation project with many lawyers challenging IAP decisions through the 3 levels of adjudication in the IAP and then up to 3 levels of court, arguing that each of their cases was exceptional. And it just seemed like 6 levels of adjudication cannot be what the parties had intended. So despite, in the end, dozens of court challenges to our adjudicator decisions, the courts returned fewer than a handful of claims to us out of 38,300. Still, this judicial recourse explosion of litigation eroded confidence in our adjudicators and destabilized and delayed the conclusion of our process. It is notable that in every settlement of Indigenous class action since the settlement agreement, the parties have expressly stipulated that there is no access to the courts for these purposes. Another litigation project that happened was to do with procedural fairness. And in the IAP, an assault by a fellow student was compensable only if the survivor proved the school staff knew or reasonably ought to have known that such abuse was happening. Now, this could be challenging, particularly for people that were very young children at the time. But as the process unfolded and abuses by students were established, Canada began to make admissions of staff knowledge. Those admissions could be relied on by subsequent claimants. This meant that some early claims were dismissed that would have been successful if made later. I reopened some of those early dismissals based on procedural fairness, which I found to be an implied term of the IAP. Canada objected and asked the court to find that I didn't have the right to reopen decided claims. The BC judge agreed with Canada and found that by imputing the notion of procedural fairness into the IAP, I had effectively amended the settlement agreement without justification or jurisdiction and undermined the finality of the process. The BC Court of Appeal agreed. However, the minister responsible ultimately announced that Canada would settle these claims, affecting up to 240 survivors. Was it the path I would have chosen to achieve this result? No, but my decisions did ultimately lead to achieving fairness for many survivors who had been abused by other students. Now, just when you thought that I had managed to inflame everyone I was working with, there's more to come, you'll be happy to know. This section I call Shots Across the Bow by a Judge. It's common when a tribunal's decisions are challenged in court. And on the advice of Joe Arvey and Catherine Boyce Parker, I participated in several requests for directions, not to defend individual adjudicator decisions, but to make submissions on the standard of review and jurisdiction. In September 2018, Joe Arvey called to say he'd received a direction, well, let's call it a decision, from the Eastern Administrative Judge. Remember, there were 9 judges. We'll call him the lead judge, regarding my conduct and wanting to know when the hearing had taken place. Neither Joe nor I had received notice of any such a hearing, but the direction found that I was insubordinate, overtly partisan, openly defiant of the supervising courts based on A, the content of my facta and 3 pending judicial recourse and other appeals, B, my failure to describe my participation in those appeals in a report to the courts, And C, my holding in abeyance several re-review adjudications pending the outcome of the procedural fairness appeals. So this came completely out of the blue. I was directed to withdraw from these pending appeals within 3 days or appear before the lead judge to show cause why my appointment as chief adjudicator shouldn't be rescinded. My access to funding for legal costs was withdrawn unless court counsel gave his approval, which he did not in this case. Joe Arve, again, he stepped up. He offered to represent me pro bono, if I picked up his disbursements. And well, I didn't have to take her up on this because of the way things unfolded. My wife did offer to pick up those disbursements. So anyway, Joe brought an application to the Ontario Court of Appeal for a stay of this direction, which was granted by Justice Sharp. And he found that there were serious issues as to whether a finding of misconduct against the lawyer should have been made without giving the lawyer an opportunity to respond, and that I would suffer irreparable harm if a stay was denied. He issued the stay retroactively to the date of the direction. This allowed me to facilitate the retention and payment of counsel. So I was able to ensure that Joe Arve was paid and not have to dip into my wife's retirement funds. But just before the appeal was heard, the lead judge issued a second direction, again on his own motion, no notice to anyone. In this one, he purported to rescind his first direction and to appoint an amicus curiae to bring a request for directions to be heard by supervising judges from Quebec and the Yukon. You can imagine the response that I had with that one, but we were again granted a stay of this second direction by Justice Sharp. And ultimately, despite Canada's support for the lead judge's directions, my appeals against both directions were granted by a unanimous panel of the Ontario Court of Appeal. None of the three courts in which my participation was objected to by the lead judge prohibited or limited it. Still, prevailing in this bizarre legal conflict with the lead judge levied a heavy personal toll and distracted me and our team from our main task of completing the IAP. I've got just a few minutes left, and I'm going to just forge ahead with a few other points to leave you with. Post-settlement agreement issues that have emerged in class actions by Indigenous people against the government. Several have been brought against the government since the IAP. In 2016, the Labrador residential school settlement addressed claims arising out of 4 schools that had been left out of the settlement agreement, apparently because Newfoundland was not yet part of Confederation when those schools were set up. In 2018, the 60 Scoop settlement was approved, the federal day school settlement in 2019, and the foster care settlement in 2023. These settlements had shared several characteristics, presumably based on lessons learned from the IAP. These include claimants are presumed to be credible and their claims are processed administratively, not through adjudication. There's no access to the courts. Canada's responsibilities end when it cuts the check. It has no role in administering the compensation process. If it is paid too little, compensation awards are prorated and reduced. If it overpaid, the awards are increased. Significantly, there are no truth commissions or public education functions. Now, no doubt these newer models bring significant benefits to the government. Canada has no further responsibilities and its financial obligations are capped with a single payment. And it also avoids this uncomfortable dual role of promoting reconciliation while remaining on in an adversarial role. There are also clear benefits to claimants. They achieve a more expeditious result, an important element of justice. With no hearings, they don't risk being triggered by facing a challenge to their credibility. And because there are no hearings, legal fees are all paid by Canada, so this reduces the risk of financial exploitation. Some questions remain, and these are for survivors alone to consider and answer. Did some claimants value the opportunity to share their experiences with a neutral adjudicator? A doctoral psychologist who assessed hundreds of survivors told us that for many, the IAP hearing was a turning point, one of the most important days of their lives. Did some find it meaningful to have their experiences validated by an adjudicator? Was an in-person apology from government or church reps important to some? Because these later settlements contain no mechanism to compile a historical record, as was done by the TRC, is there concern that these histories are not preserved? Will the absence of such public or private accounts support or undermine long-term healing and reconciliation? Regardless, the trends in settlement of mass tort claims are unmistakable. It's now all about a quick and efficient distribution of proceeds. These are often managed by accounting firms. However, there are real questions that need to be answered because it is inevitable that new mass tort claims will emerge. One thing can be said with certainty. With some certainty, there will never be an open-ended process like the individual in-person assessment of historic claims embodied in the IEP, nor a public education process like the TRC. We now have a wealth of experience in addressing state-inflicted and institutional wrongs, and the only way such settlements can move us along a path to reconciliation is if survivors and their communities are listened to and their needs remain paramount. Closing remarks. The settlement agreement has not erased the legacy of residential schools. The path toward true reconciliation lies ahead, but this agreement does prove what can be accomplished when Indigenous leaders, government, church, and above all, courageous survivors unite in purpose. Many people advocated tirelessly for the IAP to ensure survivors receive what they've been promised. Whether Justice Winkler, when he imposed this fee review process or limited fees charged by counsel, or actually took the IRS file with him when he was elevated, the IAP Oversight Committee of Stakeholder Reps and its chair, Mayo Moran, or Dan Ish, who unexpectedly rose in the gallery of a Vancouver courtroom before we had legal counsel in such cases to eloquently inform the judge of the implications for the IAP of the practices of Mr. Blott. And there were also amazing deputy chiefs that I need to acknowledge. But here, I single out two whose contributions are most relevant to this talk. Susan Ross for her privacy law expertise and invaluable advice on the records case, and Catherine Knox for her often thankless but vital work as investigator into alleged financial exploitation. Her work ended up benefiting many survivors who will never know of her unrelenting efforts on their behalf. But make no mistake, the true advocates for this process were the survivors. They fought for years for justice and the creation of the process they wanted at the negotiating table and in the courts. They advocated for themselves by coming forward at their hearings and bravely saying what needed to be said and what, frankly, needed to be heard. And they taught us something else important, which, if we didn't know it before, we know now. In the prescient 2014 words of our then executive director, Dr. Akiva Startman, long before the federal day schools, 60 scoop, and foster care settlements. Perhaps the most compelling lesson to be learned from the IAP and from the thousands of individual histories it has generated is an unfortunate truth. When vulnerable people are placed in an institutional setting without personal power or without someone to speak for them or protect them, there is a high risk they will be victimized. The experience of residential schools was in many ways exceptional in scale and scope, affecting as it has generations of Aboriginal people. But the examples of institutional abuse are legion and unfortunately ongoing. Therefore, it is important not only to provide reparations, but to learn from it, to protect the vulnerable members of society, to accept diversity and resist institutional pressures for conformity, to guard against imbalances of social power, and to be skeptical of demands to cede voice, independence, and freedoms. I will leave you with two of the many indelible memories I have of survivors I was privileged to meet with in the IAP. I remember a couple who were hunters, and they rode their snowmobiles a long distance into their northern hearings, arriving in beautiful handmade beaded moose hide outerwear, from mucklucks to their hats. Their faces had turned to icicles, but quickly melted into broad smiles. And I remember an older gentleman who testified as a young student, he borrowed an ill-fitting pair of skates from a staff member, and he began to skate away from the residential school on the Arctic Ocean towards his home community. He didn't realize it was hundreds of miles away. But to me, these images were pure poetry. That's all I have for you. Thank you very much for listening.
So thank you very much for this Halyk lecture. Those who have questions for Mr. Shapiro can come up and talk to him after, or talk to him in classes throughout the week. He'll also have office hours in room 224, the office he'll be in. He'll be in there intermittently, but also, especially on Wednesday morning, he has some open office hours for students. We're going to have a student come forward and present a thank you gift, and then we're going to have the dean come forward and present a certificate to recognize Mr. Shapiro as our Halyk chair, and we'll get you to class still on time for 1 o'clock. So please do come forward.
Thank you very much. That was very powerful. That's great. Thank you so much for listening. Oh my goodness. I can hang that in my new office upstairs.
Stand out front.
Sorry?
Here you go. I stand out front so people can see. Kate's going to do a photograph.
Thanks.
Great job. Okay, and thank you once again to Dan Shapiro for this wonderful.